2 more January 6th hearings are in the books. 6 live witnesses testified and over a dozen depositions were played, all Republican witnesses, conservative witnesses, witnesses who worked for Donald Trump, and all saying Trump violated the law, except, of course, for John Eastman, Trump's lawyer, who pled the fifth 100 times, and we saw that video. Popok, there are some new revelations, and it seems that based on what we've learned, could Trump himself be charged with attempted murder? I mean, it seems that that's what he was saying regarding Mike Pence. So let's break that down and talk about that. A federal judge denies Steve Bannon's motion to dismiss the contempt of Congress charges brought against him by the DOJ. And his trial is set to begin next month. Steve Bannon files a motion to exclude evidence of the actual insurrection. But Popok, I thought Bannon said it wasn't really that bad of a thing and that this was a celebration. So what's he worried about? Obviously, we know. The Not So Proud Boys terrorist organization asked for a continuance of their trial from late in the summer in August to about December. They also seek a venue change from Washington, D.C. to Florida. Let's break down, Popok, why they're making that request. Pocket pardons. You and I get asked this all the times. What are they? Did Trump grant them? If he did grant pocket pardons, what are their implications? Are pocket pardons constitutional? We will talk about that. And more evidence emerges showing that Ginny Thomas, the wife of Supreme Court Justice Clarence Thomas, was in communication with John Eastman, the man who pled the fifth 100 times. And let's just be blunt here. She was basically one of the leaders of the insurrection. And the January 6th committee would like a word with Ginny Thomas. And let's also talk about some Supreme Court decisions. Let's just talk about one on this podcast today. Let's talk about one in California, a way that California employees would get around arbitration provisions. This was rejected in an 8-1 decision by the Supreme Court, and a Google class action settled for $118 million, a gender discrimination. Female employees getting $118 million if this class action is approved. Michael Popok, we have an action-packed, court case-packed, legal-packed episode of LegalAF. Great to see you today.
You too. I'm breathless. You and I, again, we're doing that cut down. We start with, just everybody knows what goes into this. We start with 20 or 30 stories that we're following closely during the week. Of course, Jan 6 took a lot of the oxygen out of the room for us as we, for the Meidas Media Network, do commentary for it. But there's other things going on that we have to keep our eye on the ball and not lose sight of and bring it to our Meidas Mighty and LegalAFers. And you just gave us the top 6 consequential stories that you and I picked for our audience for today.
I want everyone also to put on their radar the fact that the Supreme Court will be issuing more opinions next Tuesday and Thursday. So this podcast is being recorded June 18th, 2022. And so expect massively consequential decisions happening on June 21 and on June 23rd. And we're talking about 18 cases that remain to be decided. And these are the cases that we've talked about on this podcast. The case that will likely be overturning Roe v. Wade and the rights established by Roe v. Wade and Casey, cases on the Second Amendment, which will likely expand significantly the right of individuals to bear arms with unfettered regulation, just to basically run around with guns. I mean, so we'll see the expansion of the Second Amendment there, cases on climate change and religion in schools. And just by putting those topics up, you could pretty much know where the Supreme Court is going to land on the issue. On climate change, they're not going to take the pro-climate change side. On religion and schools, they're going to likely make rulings that would make religion more prevalent in public schools. That's the trend that they've been obviously taking. So we will be following those decisions as they happen and giving alerts there. But Michael Popok, why don't you start by taking us through just this why don't you take the Google case and explain the settlement there, and I'll briefly talk about this PAGA settlement.
I think it's a good split because you practice regularly in California. And you and I have been involved with PAGA cases in the past, but let's start with Google because they've had a good week for justice, terrible week for Google. They already settled $100 million case earlier in the week related to their use of biometrics without having disclosed it in a class action. But this one goes to the heart of what you and I do for a living when we're not podcasting, and to gender and equity equality in America. A very good class action law firm that you've talked about before on this podcast brought in 2017 a class action suit on behalf of all female employees of Google who, both upon hiring, were ranked lower than their male counterparts and therefore got initial compensation that was lower than them, and throughout their careers, as a result, did not get the bonuses and compensation that their male counterparts with the equivalent pedigree and credentials received. And the statistics that they did, and this is how you do it, and a gender equal pay case, is that you actually get from the company, if you're the plaintiff's lawyers, a download of all of their data that they have to keep related to pay and gender and positions and titles and credentials. And you can see, you and I have been involved with these cases, you can see gender equity and disparity in pay pop out as soon as you see the statistics. And in the case of Google, a female with the same credentials as her male counterpart sitting next to her was making on average $17,000 a year less than the male. There was no dispute about that. Google had some defenses, and of course, they didn't admit liability in the settlement. But the settlement is $118 million plus a 3-year independent monitor who's going to monitor Google's practices, look at all of the equity data for new hires. Also, in response to this lawsuit, which is not part of the technical settlement that the court is going to approve or not approve on June 21st, Google on its own, but in the face of the lawsuit in 2020, raised the pay for thousands and thousands of female employees voluntarily, but in the face of the lawsuit. So, and they got an additional, it looks like that part of it was another almost $5 million in pay increases, plus this $118 million, plus 3 years of having a monitor basically sit in your HR department to make sure that all your future hires and how people are treated for bonuses and other things is treated equally. And so this is a real big win for women in the workplace because Google's not the only one doing this. And now the signal is out there that you better settle cases if you have, and you better do an internal review, look in the mirror, which is what companies do, and make sure that you don't have a gender equity problem. And if you do, you better fix it, or a big bad plaintiff's law firm's going to come along and take a few $100 million or $1 billion off of you.
You know, what's interesting about this case, Popok, though, is that it's a gender discrimination case that was litigated, this one was filed in a state court, but that was filed in the courts. There was not any arbitration provisions here. And that's an important point to point out, that the reason that there wasn't, though, as I looked into it, Popok, was that within Google itself, and large corporations, there's been movements by employees to not allow their corporations or to object to the companies they work for putting arbitration provisions within their contracts. You know, about 60 million Americans, this is the stat, have signed forced arbitration provisions. And many of you listening, if you work for a private employer in a non-unionized setting, you've likely signed an arbitration provision with your employer, and you may not realize it. It's probably in your employee handbook. Yeah, it's probably in your employee handbook. When you click just I accept, you're signing arbitration provisions, and this prevents you from having a day in court, but it allows you to adjudicate your claims in a private arbitration setting before a retired judge. or a retired lawyer. But here, this case went through the normal kind of class action process. Google filed some motions to dismiss, but they were very technical grounds about what constitutes the class and the years. And one of the things too that corporations have found, actually, while arbitrations were supposed to be cheaper, actually doing individual one-off cases within arbitrations could cost a few $100,000 just to litigate the actual cost of the arbitration. So if you do that writ large with thousands and thousands of people, before you even deal with the actual payouts that would be owed, in a settlement or in a judgment, you may be paying hundreds of millions of dollars for the cost of arbitration alone. And one thing I'd mention is, there was a seminal Supreme Court case called Walmart versus Dukes. This case was in 2011. It was a case in which the Supreme Court ruled that a group of roughly 1.5 million women who worked at Walmart could not file a gender discrimination case because it didn't meet the class action requirements for having common and typical claims. And this Walmart v. Dukes case was really the death knell to gender discrimination, style class action cases. And then you layer on that the arbitration provisions that were taking place. And so it's just very interesting to me, Michael, that in light of Walmart v. Dukes, how this law firm was able to utilize a California law, get around the there was no arbitration provision, which could have been a death knell, number one. Number two, using California's Equal Pay Act, a very specific law, to find this kind of commonality and to push for this relief on a class-wide basis, I thought was just very good lawyering.
Let me give you, I agree with you. Let me give you two softballs back to you. One, do you think that do you think Google would have taken pay equity and pay disparity seriously in their workplace had there not been the ability to thread the needle and for these lawyers to have brought a state court claim on behalf of a class action that was certified a year ago? Do you think we would have seen anything close to the result if there had not been a class action brought on these issues?
No, I mean, it's why the class action as a remedy, though, is so important, and why plaintiffs' lawyers, but civil rights lawyers fight for this remedy, because when you are able to bring together a group of similarly situated individuals, the power of the class is significantly more than the power of the individual. And when a corporation can divide and conquer the individual employees, you're not likely to get this outcome.
So here's the tension that you're going to pick up next in the packet discussion. The tension is that while the federal courts and the Supreme Court are okay with class actions as a vehicle to be brought to remediate and remedy injustice, they are big time supporters of arbitration, which is really a pro-corporation vehicle. So much so, wait till you start talking about the Alito decision next. This tension that the Supreme Court is in love with arbitration and will defend it against really almost anything in its path, and the role of the class action in society to remediate things that an individual and one lawyer can't come to grips with. Environmental disasters, dirty water, polluted water from a chemical plant, causing massive injuries in a community, pay inequity that we just talked about, products liability cases where a product damages somebody. That is what class actions were invented to do. It attracts high caliber lawyering who get compensated to represent a mass of people who have the same or similar injuries. When you break them down, it's divide and conquer. And this is that tension that you're going to talk about next, that the Supreme Court, having fallen in love with arbitration, never seems to resolve in favor of the little guy.
Agreed completely, Popok. And so in California in 2004, the California Labor and Workforce Development Agency, the LWDA, which is authorized to assess and collect civil penalties against employers for certain violations of provisions of the labor code, were assisted by the California legislature, which basically said the LWDA lacks sufficient resources to enforce the labor code. So the legislature enacted something called the Private Attorney General's Act, or PAGA, which took effect in 2004. And PAGA allowed individual employees who were alleging violations of the labor code, that they experienced, to basically bring these class action claims and to recover on behalf, as the statute says, the Private Attorney General's Act, to basically act as private attorney generals and to sue employers for violations of the labor code, not just on their own behalf, but on behalf of all of the other employees who worked for that employer. And what the PAGA statute said is that there would be civil penalties, and the default penalty was about $100 per employee per pay period for an initial violation, $200 per pay period for subsequent violations. And then there would be attorney's fees as well. And so when you would be able to recover all of this money against the employer for violating the labor code, 75% of what was recovered would go back to the state, 25% would go to the lawyer and to the class for recovering this fee. So you'd get to keep 25% of the fee. And what was able to do is this was kind of viewed as an end run around also arbitration provisions, because you were acting as an arm of the state or agents of the state, where California courts had always interpreted this PAGA statute is that it would be against public policy to have any provision in your employment agreement that would basically waive PAGA or prevent or force PAGA into an arbitration. And so these PAGA claims were a way around arbitration, and that individuals who brought these PAGA claims would bring their individual claims, as well as California courts interpreted it, into California courts and not into arbitrations. Well, the corporations challenged this provision in a case called Viking River Cruises versus Moriana. This case went to the Supreme Court, and what the Supreme Court just ruled this past week is that if you're alleging PAGA claims, inherently what you're alleging is still your own individual claim, your own employment and labor code claim, and therefore if you are bringing your own labor violation claim, that your own claim should go to a private arbitration if there's an arbitration provision in your agreement. And because you have a remedy to go to the arbitration, you really can't bring a representative action on behalf of an entire class because your individual claims have this remedy and therefore no class action. So the bottom line of this case is that these labor violations in California are not going to really be able to be brought anymore the way they were before as class actions as a result of this decision. Now, there was some interesting infighting in this decision. It was an 8-1 decision. Believe it or not, the one who was against this ruling was Clarence Thomas. And Clarence Thomas just believes that states should be able to make up whatever rules they want to make. And let me be clear. Clarence Thomas is not doing this because he supports the employee's rights in this specific case. What Clarence Thomas is basically saying is, I think states can basically make whatever rule that they want to basically not allow anyone to do to litigate if they want to. So even though he sided here with apparently the employee, it was not a pro-employee decision by Clarence Thomas in this PAGA decision.
It was a pro-state sovereignty, states' rights.
Exactly. Yeah. But here we're going to have less arbitrations, less employee rights, but you have, 8 other Supreme Court justices who were basically, who were united. They took different approaches to how they got to the outcome, and the judges appointed by Democrats were basically saying, look, the way you wrote the statute in California wasn't great. Go back and rewrite the statute to create a different way that you can give employees standing.
It's another example, and there's about a dozen of them over the last 5 years, where the Supreme Court goes back and chastises California legislature, California courts, and the Ninth Circuit, and says, you got it wrong when it comes to arbitration. There's this constant fighting. And of course, in rock, paper, scissors, the Supreme Court beats California in every time. But I give it up to California. They keep trying to preserve the rights of employees and collective action and representative action, like the private attorney general statute. And the Supreme Court keeps saying Federal Arbitration Act prevails over everything. In fact, I thought one last line on this, then of course we'll move on. Alito says because Alito wrote the opinion, not great when everybody's siding with Alito on a majority opinion. I hope that doesn't hold for abortion. But here Alito says that he's so concerned about the equal treatment. Think about this, Ben. He's so concerned about this concept of equal treatment of arbitration against litigation, because he says that in the past, state court judges especially were against arbitration and always ruled against it. And so there needs to be equal treatment. He's only concerned about equal treatment when it comes to arbitration. He's not concerned about equal treatment when it comes to human beings and discrimination. But, this is the problem with the supermajority right wing, or what they refer to as the conservatives. They only care about contracts. They only care about the statutes as they read them, but not the individual.
Absolutely, Popok. And so what we try to do in LegalAF is try to sneak in some very technical law to improve your legal education. But let's get into really, what's the state of our democracy right now, Michael Popok. I want to talk about this Joseph Biggs motion to continue the trial, which it seems the DOJ is in agreement to continue the Joseph Biggs trial itself to December. I want to talk about that. But what the DOJ was not in agreement with was Joseph Biggs' motion to sever the case so that his case can be tried separately from Tarrio and the other Proud Boys, and some of the other relief that Joseph Biggs was seeking. And the DOJ was definitely against transferring the case to Florida, where Joseph Biggs would like.
I want to talk about Miami, why they want to go
this
there.
Case to be heard. Mm-hmm. So let's start with there, Popok. Why does this terrorist, Joseph Biggs, want to move the case from Washington, D.C. to Florida? And then let's talk about after that, why does he want to continue this case to December? Why does DOJ agree that this case should be heard in December?
Let's start with Miami, because they don't really have, other than Tarrio, who's from there, the others don't. So just to remind the LegalAFers, these Proud Boys are joined together in an indictment under a conspiracy to commit seditious overthrow of the country. The conspiracy is important because Tarrio, this guy Henry Tarrio, or Enrique, whatever his bullshit moniker is, Tarrio was not in Washington or at Jan 6th, but is tied together in the conspiracy to do the violence, to do the sedition and the insurrection part of it. And we'll talk about, before we leave the segment, the memo that was written for the Proud Boys, the 1776 returns 9-page memo, which ties them all together in the attack on Jan 6th and other attacks that they were going to do to occupy other buildings around the Capitol. That's what we're talking about. That's the trial. And Joe Biggs is one of the leaders. Why that name sounds familiar to LegalAFers and Meidas Mighty is because if they went on your brother's media network with you to watch the first day, Joe Biggs had a very big, no pun intended, role in the first day of the first hearing of the Jan 6 committee, because he was the Proud Boy that had the interaction with with Carolyn Edwards, the police officer who described the carnage of being attacked, and she described quite poignantly what Joe Biggs did on behalf of the Proud Boys on that day. So now, of course, his lawyers said, he can't get a fair shake in DC. He was just the star of the day one of the Jan 6 committee hearing, and he can't get a fair shake there. And interesting, as you pointed out in the opening and just now, Ben, he wants to move it not to just some random place. He wants to move it to Miami. Look, there's been plenty of reporting, including through the Meidas Network, that Miami, the Republican Party in Miami, has been infiltrated by people like the Proud Boys. That there is, because of the demographic shift, because of the group that is in power in Miami, primarily Cuban American and from other regions in Central and South America, are moving sharply to the right in their political views. DeSantis supporters. I was down there, as people know from prior podcasts, I was down there to be a poll watcher during the last election. 4 years earlier, that was solidly for Obama. 4 years later, I can't describe to you the amount of vitriol, the amount of violent language that was on the streets against Joe Biden and Kamala Harris in favor of Donald Trump in a way that was shocking to me, having lived there for 20 years, to see the change. Latin radio is primarily Republican now. It's bashing Biden and Kamala on a regular basis. It's pro DeSantis. So they think that with the Department of Motor Vehicle records, they'll pull a better jury in Miami that leans right, literally, in their political views, which will be a more hospitable forum for them of a jury of their peers than what they think is the liberal, or in one of the papers, Joe Biggs's lawyer said the kooky, lovable people that live in Washington, D.C., almost like the liberal, effete, woke snowflakes in DC is what he really meant to say, versus what he thinks he'll have a better shot in Miami. By the way, despite the fact that this is a Trump judge, we like to out our judges on this show. Judge Tim Kelly, by the way, he's no shrinking violet. Tim Kelly, even though I don't like the fact that he's a member of the Federalist Society, he went to both of our alma maters. He went to Duke for undergrad. He went to Georgetown for law. He was also the chief counsel for national security for the Senate Judiciary Committee, and he was affirmed 94-2 by the Senate when he became. So he is, we may not like his political leanings, but he's ruled properly with things related to Trump in the direction that we think he should have ruled. He is not transferring this case to Miami. There's been 5 cases already tried by the Department of Justice against Jan 6 insurrectionists in DC. Yes, they're 5-0, but they're 5-0 because of the overwhelming evidence against these people, including the future case against Joe Biggs. So prediction, motion for venue change, denied. And let's talk about your other questions.
Let's talk about the continuance request, but I agree with you, Popok. The venue change is definitely going to be denied. And one of the bases it's also going to be denied is that if the argument is that so many people watched the hearing, over 20 million people watched the hearing, it's interesting that, when they want to go on their own podcasts and try to provide disinformation, right, to their echo chamber, they go, nobody watched it. But then this is the thing that they do when they go to actually in court and they have to testify under oath. Right. They go, so many people watch this that it's not going to be actually a fair trial. But the argument that the DOJ makes, and the argument that Judge Kelly has also said before with previous requests, that if this is pervasive information that is known to the entire country, whether you're in one venue versus the other, those same issues are going to remain. And the voir dire process, the jury selection process, should be sufficient to ferret out which jurors, would maintain a bias to make them not capable of being proper jurors in a specific case. You mentioned some other rulings by Judge Kelly. Judge Kelly presided over CNN versus Trump, right? That was the lawsuit about Trump's decision to revoke Jim Acosta's White House press credentials, denying him access to White House grounds. And then Kelly ruled that Acosta could return to the White House pending a trial. So that was one of the decisions that he made, which was a decision against Trump. And then on December 28, 2021, Kelly also denied a motion to dismiss the indictment of Proud Boys as well, who were charged with conspiracy. So that's another ruling that he made. Now, in terms of the continuance, this was, we saw a filing by the DOJ where basically they said, we're actually okay with it being moved to December. And the reason they give, Michael, is that they say that they're waiting on the transcripts from the Jan 6 committee, that they want to turn over these transcripts to, they have an obligation to turn over these transcripts, to the defendants in this case, and that they kind of wrote a little bit of a nastygram about the Jan 6 committee not giving them documents and not turning over the records. And there was a little tiff we actually saw this past week between the Jan 6 committee and the DOJ, co-equal branches of government, the executive branch and the legislative branch. But really what the Jan 6 committee, the undertone is that, you're the DOJ, like you should have access. Aren't you doing this investigation as well? Why do we have things that you don't have? Even if we have these transcripts, as a legislative body, we want to hold it close to the vest what we have. But you're the DOJ. You have a grand jury. Go subpoena these same people. You have the same ability to do what we're doing over here. But should they just be sharing these records with them, Popok?
Yeah, let's talk. There's two cases today, two segments today where this becomes relevant. We're going to talk about Bannon filing a motion in limine to keep out the Jan 6 attack, and the same issue. Department of Justice lawyers are now having to appear in court and explain to the judges why they don't have the Jan 6 transcripts and video transcripts. Why is that important? You alluded to it earlier, because under a concept called Brady, based on a case, Brady material, which is material that could help the defense, has to be provided to the defense by the prosecution. And so the defense is saying, and to be frank, they're not wrong, hey, I want to see the video of me, my client, at the Jan 6th. I want to see the interviews that were taken about his participation. And the Department of Justice has to have taken a sheepish position in now two court appearances, if not earlier, and say, we don't have them. And the judges are like, what do you mean you don't have them? Well, the Jan 6 committee is not giving it to us. Now, to your point, which is a problem. Now, what I've seen in the recent reporting is that the Jan 6 committee said they will turn them over to the Department of Justice, but not until, Ben, did you see this? Not until around July. I guess they want to get over their hearings before they turn over, because they don't want any leaks. They're doing their own thing. They're putting on a major hearing right now. So July doesn't help some of these trials. So there's a continued tension here. Department of Justice, let's make a couple of points here. They can't order. And I mean, could they? No, I don't think they could subpoena successfully the Department of Justice, the Jan 6 committee, to get it from them. So they're stuck, and they know that. Now, to answer your question, or answer the question of Benny Thomas, don't you have these already? The answer we know is no. The Jan 6 committee is so far ahead in terms of development of their case, the 1,000 of interviews, the hundreds of thousands of pages of documents. We know the Department of Justice is at least 6 months behind, because we know, yes, there's 3 grand juries or more impaneled in Washington right now, but they're playing catch up. The Jan 6 committee has been going on for over a year. So that can't be the answer. What do you think the end result is for the Jan 6 committee turning over with a ribbon tied around it all of their materials to the Department of Justice? Does it happen? When does it happen?
I think it happens after they make their closing argument.
Yeah, agreed.
And I think it probably happens it's a lot of material. They're releasing the material to the public. When you watch these hearings and you see Benny Thompson say, we hereby release the deposition transcripts and make them part of the public record, he's not referring to just the clips that we're seeing. He's actually referring to making the full deposition transcripts available and part of a public congressional record. and basically taking these as confidential documents and moving them into the public record. So they're doing that naturally right now as the process is taking place and moving these videos into the public record. But they're going to do it after their closing argument, after their statement, because here's what they're going to say. They're going to say, DOJ, we have made a case that is beyond compelling. Now the job is in your hands.
Yeah,
here you go. Here's the records that you saw. And they want to sequence it that way to put the pressure on the DOJ to do the right thing.
And the judges, I agree with you. And the judges are just going to have to make a ruling that the Jan 6 committee information and data is not Brady material because A, it's not in the hands of the Department of Justice, obviously. It won't be for some time. Now, when the Department of Justice does get it, they will have to turn it over one by one to defendants who request it. If it goes to their culpability or an attempt at a defense to their culpability, what we call exculpatory material at that time. But if your trial, and some of these trials have happened already, you as a defendant can't say, oh, if I had only had some of that material from Jan 6, it could have helped my case. It's over. It's over. It's not Brady material until it gets into the hands of the Department of Justice. That's what they said to the judge in the recent case involving Biggs, and they're gonna say the same thing in the Bannon case we're going to talk about next.
And Popok, what was this filing? Touch upon it briefly by Zachary Rell, one of the co-defendants of Enrique Tarrio, this 1776 returns document. And I've seen different analysis done on this to see, is this document like incredibly helpful to prosecutors? Is it not helpful to prosecutors? And the 1776 return document basically is one of the plans and the plots that the terrorist Proud Boys had to occupy the buildings on January 6th and to make their demands be heard and to shut down, Congress. But the documents themselves don't actually talk about going into the Capitol. They talk about occupying and basically holding hostages in other buildings. And so it's part of the development of their sedition. It's ultimately not the final piece of what they decided to do.
Yeah, they called it audible on Jan 6th, and or this was part of all the planning. So in March of this year, just to continue our build of information that we provide on the podcast, in March we talked about the original indictment of Tarrio and 5 other co-conspirators, all Proud Boys. And in the March indictment and in the courtroom, the Department of Justice mentioned a memo that they had, and the New York Times did a whole report of it in March. And I'll post it on LegalAF community later today, in which they suggested that the memo was part of the plot and was the PowerPoint, if you will, that led ultimately to the tip of the spear, which was the Jan 6th insurrection and attack on the Capitol. It was an attack and a infiltration, to use their words, of 7 other buildings around the Capitol, all at the same time, to be held and occupied by groups of 50 or more of the Proud Boys and others, led by a Proud Boy in coordination. Sounds an awful lot like a conspiracy, which is what the government said when they brought the indictment. Now, I want to get your opinion on this as a trial lawyer, in a curious move, one of the co-conspirators decided to rip the Band-Aid off and actually file the memo in an attempt to move to dismiss the indictment against them, arguing that the memo is innocuous. The memo, there's no real link between Tarrio and my client, in this case, Zach Rell, R-E-H-L. This is the lawyer's argument. And if you look closely at the memo, which I've attached to my motion, all 9 pages, it says that the steps of the plan are infiltration, execution, distraction, occupy, and sit-in. But they're almost acting like, it's like a sit-in. It's like when college students don't like the food that's served in the cafeteria, so they go sit in the lobby of the dean. It's just like that. It's just, fun and games, just the way Jan 6 is portrayed by those like Jim Jordan who don't want to admit what happened. It's just a little, hugging and sit-in and, got a little bit out of hand. That's what they want to portray it as. So they made a tactical decision. I want to get your opinion on it, to actually file the memo and say the memo's not that bad. It didn't talk about violence. It didn't talk about the overthrow. And therefore, there's no conspiracy. And even the government's own document supports that. What did you think about that argument?
I thought it's the stupidest move. It's the dumbest move in the.
I was like, why are you filing the memo?
In the history? Why? Look, I'm glad this idiot terrorist did it, because, the more information that's out there is the better for justice. But if you're representing a criminal defendant in this case, you tell him to shut up. You don't give more information than you need to do. You have a Fifth Amendment right against self-incrimination.
Here's the memo I relied on.
In a criminal proceeding, obviously, here's what I want people to know too. In a civil proceeding, if you take the fifth, it can actually be used against you as an adverse inference by taking the fifth and by not testifying. In a criminal proceeding, if you take the fifth, you are not allowed to point out as the prosecutor that this person invoked the fifth. You're not allowed to show the video the way they did in January 6th and show the person pleading the fifth over and over and over again on stand. You can't do that in the criminal case, in the criminal proceeding, because you don't have to testify against yourself. And you can't go up and make the argument as the prosecutor, don't you think he's guilty or she's guilty? They did not testify, and they're invoking the fifth, and therefore they're guilty. You can't do that in a criminal prosecution whatsoever. So you as a criminal defendant should not be turning over these records that would incriminate you more. And also, we know what happened on January 6th. But what this also goes to, Michael, is the disunity between these defendants, the different strategies. It shows they're sloppy, they're messy, they're kind of going at it with each other. The other co-defendants were not happy. I would guarantee you that this document was filed. They were probably like, yo, what is Rel fucking doing? I mean, Rel went rogue. What's Rel doing?
Can I go to your point?
That he did, but it's the dummest thing to do if you're a criminal defendant.
Totally agree with you. Can I go to one of your points and kind of tease it out a little bit? Talk about Fifth Amendment right not to incriminate yourself. What is going on with the Peter Navarros and the John Eastmans of the world and Bannon, who continue in the face staring down the barrel of indictment and criminal prosecution and spending a lot of time at Leavenworth? John Eastman continues to blog about evidence in the case against him and respond to what we're going to talk about next, the Ginny Thomas connection. He's blogging as of like yesterday about evidence that is against him, taking an opinion or a position, which is, back to your law of holes, continuing to dig his own grave. Navarro does the same thing. I got a book that I'm releasing, Judge. Please postpone my trial so I can go on a book tour. The book is going to be like manna from heaven for the prosecution because of all the crazy crap that's going to be packed into it so he can get paid, his royalties. And then you have Bannon, who podcasts on a regular basis while he's out on bail. What do you make of that conduct, which is completely against you? And I would leave the representation of a client in a criminal setting if they continue to do that. Yes or no? Would you continue to represent that client if you couldn't control them that way?
Absolutely. And to me, this goes to what Bill Stepian said about in his deposition testimony about team normal and team not normal. What I want to be clear about is I don't believe that Stepian and the Trump inner circle was team normal, even though they view themselves as team normal. But nonetheless, they had at least a fear of the rule of law, in the sense that they understood the repercussions, they followed the norms of what the law was, and where they stopped was directly overthrowing the government, which is not exactly, we should not give them kudos for doing that. But what we have here, why I reference that, is you really see a decaying of the rule of law creep into that kind of team normal, because team normal is not really normal anymore. So team normal's at a position that we would normally view as red alert, but then you have this fascist creep, this total disrespect of the law. And what we see with Bannon, what we see with Navarro, what we see with Meadows, and of course, them working for the Trump cartel, we don't give a fuck about the law no more. The democracy, the courts, it don't matter, because guess what? Donald Trump, you heard what he said at the Faith and Freedom, whatever they call that convention. We're going to get pardons. So all we need to do is we're going to talk shit. We're going to go all in on violating the law. Ridiculous. Well, not only that, we're going to taunt the law. We're going to taunt the judge. We're going to taunt the Constitution, because that will give us more favor to get a pardon for Trump down the road, because they're all in on him running in 2024 or a fascist-like figure in DeSantis. And their view is that we're going to get pardoned. That's what. So screw the law. If we have any respect for the law, we're not going to get the benefit. That's why they're doing it. That's why they're funny. And they're also sick people. Like they're, and sick may give them, too much credit. These are really dastardly and despicable individuals who are the most un-American, unpatriotic people that exist. And they're criminals. And all they know how to do is to engage in criminality. And speaking to that, Popok, let's talk about Steve Bannon. Let's talk about, I always like to give a little bit of a teaser of who the judge is, the same way you talked about the prior federal judge overseeing the Proud Boys case in the district court in Washington, D.C., Timothy James Kelly. In this case, Bannon, it is Carl John Nichols, again, another Trump appointee, which frankly made me a little nervous early on. And you knew about Judge Nichols' background too. And you've always said that he's someone who also, even though he was appointed, is someone who has a reputation of calling balls and strikes. But where I was a little bit nervous, although I thought, how could he possibly buy this argument from Bannon, is this argument where Bannon was trying to claim executive privilege, and he was relying on this DOJ memo and saying that the advice that I have, that the case should be dismissed against me because there's this DOJ memo that basically says if you work for the president and there's this executive privilege claim, you don't have to testify before Congress. And that was one of the arguments that he made, to get the case dismissed, executive privilege. The other argument he said is that the January 6th committee is not legitimate. The third argument that he made to try to get this dismissed, which was rejected a long time ago, was I relied on the advice of counsel, which the judge says an advice of counsel defense is not a defense of a contempt of Congress charge. So those were the arguments that he made. Fortunately, Judge Nichols rejected all of these arguments and said, as far as I know, Trump hasn't even invoked executive privilege with respect to this, and that's who has to invoke it. But, it's ambiguous at best. And by the way, you were a podcaster. You're not working for the president. They didn't subpoena you in your capacity as an advisor, which may be a close call if that's what the subpoena was. But it was your conduct on January 6th and the weeks preceding it and weeks thereafter. You are a podcaster. You don't get a podcaster immunity. You're going to trial, buddy. And then Steve Bannon filed a motion in limine shortly thereafter. And a motion in limine is a pre-trial motion to exclude information. If you've heard the term motion in limine, weird word, it could just be motion to exclude. I don't think, we still use the term in limine, one of those Latin terms that we use in court, but it's a motion to exclude evidence of like January 6th itself. So he just wants the testimony to be, I was subpoenaed for some random reason to show up in front of the January 6th committee, but we can't talk about January 6th. I want to get your views on it, Michael. Yeah. I do think that some of the motion in limine will be granted.
I agree with you.
What the judge is not going to allow in is for the DOJ to make the case and show the videos of Jan 6th and show the hang Mike Pence and show all of those things. I think that the DOJ is going to be permitted to give some background to the jury. We all know what happened on January 6th. Individuals stormed the Capitol. We as the DOJ wanted to get information. We subpoenaed Steve Bannon because he was involved. Here's what we thought his involvement was in it. Yeah. He refused, limited to that. That's what will likely be.
I totally agree. And you have almost competing motions in limine. No, you have competing motions in limine. The government filed a motion in limine or to exclude because they don't want Bannon going off like Bannon the podcaster, attacking democracy, attacking Nancy Pelosi, attacking the legitimacy of the Jan 6 committee, and putting all of these crazy thoughts in the jury's head, which is not part of a defense that Judge Nichols is going to allow. And he shouldn't be able to just, be Steve Bannon, crazy podcaster on the stand and have him pollute the jury or the jury's mind. So you got the government arguing that. To your point, you're right. There are, even though I would love to fry this guy's ass with every piece of evidence possible, the federal rules of civil procedure, the federal rules of evidence in this case, have a balancing test for evidence that is relevant, what we call probative of the claim or the defense that's being prosecuted or defended in the case, and any severe prejudice that could result if the prejudice outweighs the probative value of that piece of evidence. So in other words, let me put it in lay terms like we like to do in LegalAF. If that piece of evidence would blow the jury's mind, making them incapable of properly reasoning as the fact finder, because of it, they can't get past that piece of evidence, assuming it's not the only piece of evidence that proves that particular claim or defense, then under what's called a Rule 401, Rule 403 balancing test, 401 being relevancy, Rule 403 being prejudice outweighing relevancy, the judge has to do a test. There are certain aspects of the carnage, to paraphrase the Capitol Police officer about what happened on Jan 6, the attack on the Capitol and all of that. I agree with Bannon's lawyers. That's not relevant to him being found for willfully in contempt of Congress for not cooperating with the Jan 6 committee. So I think that gets excluded. I'll give a personal example. As people know from the podcast, I worked for a Wall Street firm that had a link, unfortunate link, a terrible link to 9/11. I won't go into the details, but we had, in cases that I handled for the company, we had the other side in federal court and otherwise make motions in limine to prevent us from even mentioning, even if it was relevant to the case, the fact that hundreds and hundreds of people were murdered in 9/11 from the company on that particular day. And generally they were successful, that we were not able, not that we wanted to do it to fuel the fan the flames of prejudice against the other side by mentioning we're the company that happened to. It's just part of the corporate history of the company. And usually we want to mention it at some point. And so we were unsuccessful in many of those cases because the courts are very leery about allowing this kind of could be probative, but highly prejudicial, inflammatory material to go to the jury. I think he wins on that. He doesn't win on anything where they're bound and gagged, the Department of Justice, from telling the jury what is the Jan 6 committee, what is its role, what is its investigation, what is the scope of its investigation. This is all public record. This is all declarations establishing the Jan 6 committee. And they're going to be able to read from those. This is the scope of their authority. And this is what they did. They commanded the testimony of Bannon under a subpoena. He refused. It's willful. And here's why. I agree with you exactly. Aspects of the motion in limine for Bannon are going to be granted if it doesn't go to the heart of the matter and it's deemed to be too prejudicial. And likewise, the government, I think, is going to win the bulk of its motion in limine to gag Bannon from going off the rails in front of the jury and doing his crazy clown show, dumpster fire act in front of them. So I think that's how Nichols, who's a very sober person, is going to make sure that this trial stays on track in front of this jury.
You also mentioned before Peter Navarro. His case is before Judge Amit Mehta, an Obama appointee who we've talked about. He ruled on the civil case denying the motion to dismiss that was filed to prevent the case from going forward against the members of Congress who had filed the case against Trump and against others on January 6th for their civil conduct in causing the insurrection. So Judge Mehta is overseeing the Navarro case. And Navarro pled not guilty on Friday, this last Friday as well. And the court also entered a protective order preventing Navarro from releasing records, confidential records to the public. I want to talk about pocket pardons have been a major topic. And of course, I want to talk about a summary of what took place at the Jan 6th hearing, give everybody a summary and give you Popok and my take on that. But first, I want to talk about our partner, Athletic Greens. This podcast is brought to you by Athletic Greens, the health and wellness company that makes comprehensive daily nutrition really simple. With so many stressors in life, it's difficult to maintain effective nutritional habits and give our bodies the nutrients it needs to thrive. Busy schedules, poor sleep, exercise, the environment, work stress, or simply not eating enough of the right foods can leave us deficient in key nutritional areas. AG1 by Athletic Greens, the category leading superfood product, brings comprehensive and convenient daily nutrition to everybody. Keeping up with the research, knowing what to do, and taking a bunch of pills and capsules is hard on the stomach and hard to keep up with. To help each of us be at our best, they simplify the path to better nutrition by giving you the one thing that you all need. It's one tasty scoop of AG1. It contains 75 vitamins, minerals, and whole food sourced ingredients, including multivitamin, multimineral, probiotic, green superfood blend, and more in one convenient daily serving. The special blend of high quality bioavailable ingredients in a scoop of AG1 work together to fill the nutritional gaps in your diet, support energy and focus, aid with gut health and digestion, and support a healthy immune system, effectively replacing multiple products or pills with one healthy and delicious drink. It's lifestyle friendly, whether you eat keto, paleo, vegan, dairy-free, or gluten-free. This is for you, and it contains less than 1 gram of sugar, no GMOs, no nasty chemicals or artificial anything, while making sure it all tastes good. And boy, does it taste good. I love Athletic Greens. It's super simple for me to use. I just take 1 scoop of the green powder. I put it in a cup each morning. I shake it up. I drink it. It has been so perfect for me. Before that, I would use all these random pills and vitamins and things that I would get at the grocery store or at my local pharmacy. None of that was working. Finally, I found this AG1 and I was like, great, all I need to do is drink this. I'm good for the day. I have all the vitamins that I need. And I felt incredible energy. I felt great. And I highly, highly recommend it. So join the movement of athletes, lifeleets, moms, dads, rookies, first timers, and everyone in between taking ownership of their daily health and focusing on the nutritional products they really need in the simplest manner possible. That's essential nutrition to make it easy. Athletic Greens is going to give you an immune supporting free 1-year supply of vitamin D and 5 free travel packs with your first purchase if you visit athleticgreens.com/LegalAF today. Again, simply visit athleticgreens.com/LegalAF and take control of your health and give AG1 a try. Go to athleticgreens.com/LegalAF. Michael, pocket pardons. Everyone's saying, I know Trump gave pocket pardons. He must have given pocket pardons. Bannon, Popok, can you please talk about what a pocket pardon is? A pocket pardon, just so everybody knows, it's never been done in the history of the United States. A pocket pardon is like a secret pardon. There are pardons that are announced publicly, right? Because that's the whole concept of a pardon, that it's a public reprieve. But this idea of a pocket pardon is there anything that is preventing a president from basically writing secret pardons that aren't announced, putting them in a vault, hiding them, I guess in Trump's case, under the toilet bowl or wherever Trump hides his things, and then saying, aha, there was a pardon. I pardoned Giuliani. I pardoned myself. These pardons existed. This has been discussed by numerous constitutional scholars. The pardon power of the president is based on Article 2, Section 2, Clause 1 of the United States Constitution, which provides the president shall have the power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. Just a reminder to everybody, the president does not have the power to pardon people for state offenses and state criminal acts, only federal claims, federal charges. And we've talked about this before, potentially, it's never really been challenged in a court, but Like the pardon of Richard Nixon was a pardon for conduct that he wasn't necessarily even charged for yet. That was never challenged to the Supreme Court, but many constitutional scholars have argued that's probably okay to pardon someone for conduct that they hadn't, but it hasn't been actually litigated ever. But this idea of a pocket pardon, a private secret pardon, it would seem to contradict what a pardon is what constitutional scholars say. The very essence of a pardon is something that's done publicly. But Trump has violated a lot of norms. The whole idea before Trump about pardons was really that like an individual had to, for the DOJ, it was a process won by the DOJ, not by Jared Kushner, who testified at the Jan 6 that he was
very busy with pardons at that time.
Yeah, before it was the Department of Justice that dealt with pardons. And it was after an individual had served the time for a significant period of time. And then a number of years later, like at least 5 years after the individual had served his time, then it could be begun as a consideration. So Popok, what's up here?
Well, you and I are the constitutional scholars on LegalAF. When I stroke my beard, that's when I'm going into my constitutional scholar mode. I have to agree with Larry Tribe, and I have to disagree with somebody that I admire, Lawrence O'Donnell, who said, "Don't trust the list. There are pocket pardons." This is how this whole thing kind of started. Here's the problem I have with the concept of pocket pardons. Sounds great. It's very catchy, pocket pardons. Here's the problem with it. Pardons have to be any event has to be memorialized in one of two ways. Would you agree with me, Ben? It's either in writing or it's oral. Okay.
Absolutely.
If it's in writing, it's covered by the Presidential Papers Act. He'd have to have produced it to the National Archive. Can't literally keep it in his pocket. He's the president. He issued a paper. There's no secret pardon paper exemption from the Presidential Papers Act at all. So if it existed in paper, he would have needed to provide it. Why? Because presidential papers are really, really important from a historical standpoint and from a record-keeping standpoint. And so that we know what is the president's paper and what is not the president's paper, because it was created contemporaneously with the time that he was in office. Because on the way out, when Nixon flew away in his helicopter, like he was leaving Saigon, when he resigned, I'm sure there could have been a typewriter on that. But he's typing away, even though he's resigned. He backdates it. So to avoid that, there's we cabin what are the presidential papers. So if it doesn't exist, let's assume now, let's take my theory forward. It doesn't exist in paper. The pardon, the pardon for future conduct, for Ivanka, for Eastman, for Meadows, for the Congress people that were lining up, banging on the door like one of those sci-fi movies where the rocket ship is taking off from an exploding planet. They all want to get on before it happens, and they're closing that door, to these people. Okay, assume so it's not in paper. So then it's oral. Okay, so it's an oral pardon. I, Donald J. Trump, pardon you for all of your sins and all of your crimes against humanity and the United States Constitution. Who's the witnesses for that? I'm now the Supreme Court of the United States. Okay, it's not in paper. Okay. And what happened exactly? Well, I was in the Oval Office. I was in the dining room with Ivanka, and Meadows was there, and I gave that pardon. So he's going to have to testify. The others are going to have to testify. I mean, so far, nobody's come out of the woodwork and said, I was there for a secret pardon. I heard of it. I was, and then there's the credibility of that. This is why I think if anybody tries to claim they got a pardon from the president, not in writing, or there's a first time in the history of the United States, an attempt by a criminal president to pardon himself in advance, I think even this Supreme Court would find that pardon, having not been properly issued in writing by the time he left office, to be invalid. What do you think?
Oh, I agree with you. I think even this Supreme Court would find it to be invalid. To even get there, as you mentioned, there would have to be this mini trial, if you will, about the circumstances surrounding it. And why'd you think you needed a pardon? And you'd have to really get into the issues,
Right.
which would ultimately kind of collide with Trump's ego that he claims that he did nothing wrong. So the essence of a pardon, as federal judges have said over and over again, is that there was guilt that you need a reprieve from. So to ask for a pardon means you were guilty
John
of
Eastman.
something underlying in the exactly. And so that is where the rubber meets the road of Trump's ego and him having to say that he was guilty of the underlying crime. But would it shock me, though, for Trump to try it if he is charged and convicted, to say, actually, this is what I gave myself.
I gave myself the pardon before I left. Who'd he give it to?
I'm
Who
sure
was
there? I'm all the constitutional mischief in the world. I'm sure Trump will attempt at that situation. But Michael, I think your analysis is definitely sound. And I use the term constitutional mischief because we heard that word over and over again at the Jan 6th hearings this past week. I want to talk about day 2 and day 3 of the January 6th hearings. So day 2 took place Monday, June 13th, and day 3 took place on Thursday, June 16th. On Monday, who were the witnesses? Ex-Trump campaign manager Bill Stepian, who was not able to testify live because apparently his wife was in labor. We still don't have information. Have you got information? Do we know if they
Where's
had the
that
baby?
Where is that baby?
I don't know one way or another, so I don't want to. For all I know is that I haven't seen no baby photos.
Can I make something clear, because it came up in a Twitter feed? We, and after 75 or 90 shows, we are feminists. We are not anti-women. I am not attacking the mother, Bill Stepian's wife, when we make a joke about where is the baby. We're attacking the character of Bill Stepian to have used the excuse of that, especially if it's not true, to avoid having to give live testimony.
Well, I just think if you make that statement publicly, the public may want to know. I don't think in any other setting we should have to know, right? In this one setting where our democracy's on the line, and minutes before a hearing, we learn about that, the public has some interest to be like, all right, but where's the baby?
And let's be honest, the brothers and you may want to find out where they're registered and send a gift.
Exactly. The ex-Fox News political editor, Chris Steyerwalt, testified in person. Attorney Benjamin Ginsburg, a Republican constitutional lawyer. Ex-U.S. Attorney B.J. Pack, Republican United States Attorney in the Trump administration. Ex-Philadelphia City Commissioner Al Schmidt, who was a Republican. And then day 3, Greg Jacob and Michael Luttig. Let's just take day 2 first with all of those witnesses that they had there. I thought day 2 was incredible. The information that came out of day 2, I thought was, to me, put day 1 was nothing compared to day 2. But to hear from a Fox News, and this person said, look, I was there for the news. I was not there to play the Hannity games, and that wasn't my role. I took a great deal of pride in calling balls and strikes on elections. I was proud of the software we had. We knew that Trump lost. We called it first, and I was proud of that decision, and we were right in making that decision, and that there was no way that Trump could have won. So that came from a Fox News person. Then Attorney Benjamin Ginsburg, he was integral. He was the main lawyer, basically, who argued Bush v. Gore, for Bush, and argued cases in the past of vote counting. And he basically said the whole process that these Trumpers even went about is not how you even argue voting fraud issues, and that there's no way that with the way the votes were in the different states that you could possibly win those cases, and that there was no election fraud in this in the 2020 election to possibly change the outcome in any way whatsoever. And that was the Republicans' main constitutional expert. Then you had B.J. Pack, the U.S. attorney from Georgia, who said he looked into all the accusations that were made in Georgia, found none. And ex-Philadelphia City Commissioner Al Schmidt said there was no voter.
Republican Philadelphia commissioner.
Yeah, and said there was no fraud in Philadelphia. And when Trump used my name and tweeted out my name, the ramifications of that was I received death threats and my family's life was placed in jeopardy, all as a result of this big lie. Michael, what did you think about that day?
Day was amazing, and what the Jan 6 committee is doing is using Republicans against Trump. That's why every one of the witnesses and every one of the clips is Republicans in the inner circle, Federalist Society, dyed-in-the-wool Republicans. Stepian is currently the campaign manager, at least he was. He may not be after this week, but he was the campaign manager for the challenger to Cheney in a Trump-supported candidate. Jason Miller, who even when they don't announce a live witness, there's always these other clips that they use, talking about Rudy Giuliani being drunk on the night of the election and forcing Trump's hand or convincing Trump that he should declare that he won the election. Two different people saying that Giuliani was drunk on that day, Stepian and Miller, both Republicans. Popok saying, I resigned, profiling courage, because the president of the United States and his henchmen pressured the Department of Justice in Georgia to find voter fraud where there was none, and I resigned. The guy from Fox News, an analyst, I don't know what his political leaning is, but he's working and plying his trade on the fascist network of Fox News, said, I lost my job because I properly declared the election for Joe Biden against Trump. Republicans. These are Republicans against Trump, showing that he couldn't possibly believe the bullshit and lies of the big lie. And this all goes to criminal intent against Trump. And Stepian, even though he gave us some of the most memorable lines so far, besides when we get to Judge Luttig on day 3, which was team normal and therefore team abnormal, Giuliani and team normal, it shows you the insidious nature of what the Republicans were doing, even at the very end. Bill Stepian said, I'm a professional and I am ethical. And I didn't find anything that Giuliani was doing or that group was doing. I didn't think it was ethical or professional. So I left. But he still normalized all of this until the fall of Saigon, and he had to get out of there with a helicopter. He was there giving the imprimatur of normalcy, of nothing to see here, of Republicans are in charge and Trump's got valid arguments until the very end. So he's complicit, even though he's after the fact trying to cover himself in glory with, I was team normal. You weren't. You were part of the conspiracy that kept the flames alive that led to the insurrection. And we'll talk about day 3. So powerful day led by Republicans against Trump, whether they wanted to or not.
And then the January 6th committee, in addition to these live witnesses, would play the deposition testimony of people like Trump lawyer Eric Hirschman.
I love him.
Eric Hirschman's testimony was, as blunt as it was, saying that, these people were crazy. They were insane. I told Eastman, you better find a damn good criminal defense lawyer is the best effing advice that I could give you.
Stop on Hirschman for a minute. Let me tell you something about Hirschman. You may not know, or if you knew it, I'll tell it to the audience. Hirschman came from a law firm in New York that I know well and has always been a big supporter of Trump. It's been Trump's law firm. Before he hired all these other law firms we've talked about ad nauseum, he used to use Mark Kazowitz's firm, Kazowitz Benson, in New York. The ambassador to Israel under Trump was a Kazowitz partner. Hirschman, Kazowitz partner. He left a $3 or $4 million partnership to go serve in the White House as White House counsel. These are not Democrats. These are people who are card-carrying members of the Trump cartel, as you called it, and Republicans testifying against people like John Eastman and ultimately, by extension, Donald Trump, and the best line, and I know we've talked about it ad nauseum, but I still love it, is when Hirschman in his video recording said he got a call from Eastman about Georgia and about we got to preserve the voting machines and the fraud that happened there. And he said, "Are you out of your fucking mind? The only two words I want to hear out of your mouth next are orderly transition. Say it." And he made him say it. He made Eastman say orderly transition. And he said, "I'm going to give you the best piece of advice." And that's the one you just said about go get yourself an effing criminal defense lawyer because you, sir, need it. Because he knew as an observer of the criminal conspiracy led by Trump that was going on to overthrow democracy.
No, absolutely. Let's talk about day 3 on June 16th. You had Greg Jacob, former counsel to Vice President Mike Pence. Greg Jacobs was the top lawyer for Mike Pence at the White House at the time. And then you had Judge Michael Luttig, retired judge from the U.S. Court of Appeals for the Fourth Circuit, who was also an informal advisor to Mike Pence around the January 6th events. Compelling testimony from both. To me, where Luttig ended, this is not just about January 6th. What this is really about is 2024. By the way, Judge Luttig's one of the top conservative jurists, Republican jurist out there. And he's someone who's saying, this is our democracy's on the line right here. He said, based on his entire review of the Constitution, of historical context, there was no basis whatsoever for any of the claims that Vice President Pence had the authority to reject electors or to delay the counting of electors and throw it back to the state legislature. And then Greg Jacob, who was the day-to-day person advising Mike Pence, said the same thing. He said that we looked every angle of this. We tried to see, this is where Greg Jacob, it's like, you applaud them for doing the right thing, but Greg Jacobs and Pence were trying to find a way to actually delay the counting and throw it to the state legislature. But ultimately, they found that there was nothing and no bases to do it. And some of the most basic stuff that Greg Jacobs said when he was speaking with John Eastman, who was giving the advice to the president, is he said, look, don't you think that Al Gore would have just done that if or would you be okay if Al Gore did it? And would you be okay if Vice President Kamala Harris did it? To which John Eastman said, I would not be okay with that, but just do it here for Trump, which conceded that there was no basis. And then Greg Jacobs said, do you think you're going to win this argument in the Supreme Court? And John Eastman said, no, I think we'll probably lose 7-2, to which I think he was talking about Thomas and Alito. And then he claims he changed it to, no, we would lose 9-0. I actually think it would probably be 7-2. I do think Alito and Thomas would probably side with Eastman, but nonetheless, they would lose. Eastman knew they would lose. Eastman knew the strategy was a unlawful strategy. And then the Jan 6 committee, this is where all these LegalAFs tied together, going back to Judge Carter, say, look at what the federal judge who looked at this, U.S. District Court judge from the Central District of California, Southern Division, Judge David Carter, when he looked at all of this, said that this was a coup in search of a legal theory.
Yeah, so let's start. That's all great. I'm going to unpack just a couple of parts that I thought were the most interesting of what you said. Judge Luttig, as you said, is the rightest of right-wing judges. He was known when he sat on the Fourth Circuit. He wasn't a trial court level. He was appellate court level. But his clerks went to the Supreme Court and clerked more than any other federal judge. It was known as, his clerks were known as litigators. His name was Luttig. And he had 43 clerks, former clerks of his, go next to the Supreme Court.
Wasn't Cruz and Eastman his clerk?
30 out of the 43 that he sent to the Supreme Court clerked for either Antonin Scalia or Clarence Thomas. Eastman clerked for both Luttig. That's why he was so pivotal in giving advice to Vice President Pence in the last 3 days. He was only retained in the last 3 days to give cover to Pence to back Trump off and not do his bidding for him. But Eastman clerked for Luttig, Eastman clerked for Thomas, and Luttig basically was a feeder program on the Federalist Society to send clerks from his appellate court to the Supreme Court. So you couldn't think of a more odd choice for the Jan 6 committee to use unless you knew what his testimony was going to be. And we knew from the beginning that he said, my former clerk, John Eastman, is full of shit constitutionally. He doesn't know what he's talking about. This is what Luttig said in a tweet on the power of Twitter on Jan 7, giving Pence some cover, and then wrote a memo for Pence in which he said, there is no role of Congress and therefore the Senate, and therefore you as the president tempore of the Senate as vice president. There is no role other than the most ministerial role, unless it is clear from the voting that there isn't a majority winner of the Electoral College. Then it gets thrown to the House of Representatives. So Luttig's position is unique among the GQP, which is there's no role for the Senate in this. You just raise your hands and you certify and you are done. You are not to do anything else. You don't delay 10 days, like John Eastman said. You don't throw it to the House because you feel like it or you like you want to help the president who just lost. You don't do any of that. That's not what the Constitution says at all. And Michael Luttig had the most powerful testimony because he said point blank that Donald Trump presents a clear and present danger. Think of those words. Clear and present danger to democracy, and will continue to as an ex-president by challenging the legitimacy of the election, by claiming that Mike Pence should be hanged for doing something that would have been criminal and unconstitutional. To have Michael Luttig, of all people, if you would have told me 3 years ago, 4 years ago, or a year ago, he would be the star witness on day 3, Michael Luttig, I'd say, are you crazy? That's the one judge I never want to face in any of my cases because of his right-wing positions. But that is the power of the Jan 6 committee in its hearings. They're not using people that are independent, people that are democratic, evidence that can't be refuted. They're using Republicans against Republicans. This was the 11th commandment of Ronald Reagan. A Republican shall not speak ill of another Republican. They are using the 11th Amendment of Ronald Reagan against Donald Trump in such an powerful and impactful way that, yes, the Department of Justice is going to have to wake up and start prosecuting people like Donald Trump.
And I'll leave you with this. To the extent this is partisan, it's partisan in favor of Republicans because the only people who have testified are Republicans. The only witnesses are people who I would disagree with on every issue other than the fact that insurrectionists shouldn't storm the Capitol building and try to hang the vice president and overthrow our democracy for a piece of crap like Donald Trump. And that's why this isn't about Democrats versus what Republicans used to be. It's about people who love democracy against this MAGA cult movement. And we saw the development of this MAGA cult movement with the Tea Party. We saw it with the Sarah Palin strand. We saw it further metastasize under the Obama administration, when the Republicans were spurring it on. But see, now they've created this horrible plague that they can't control.
Yeah, it's the golem. We have it in our religion. We have something called the golem, which is created out of incantations and magic, and then it ends up killing everybody in the village because literally they can't control it.
And you have currently the only people who continue to go along with this big lie, other than, this MAGA base, which is a significant base of tens of millions that represents about 25% or 30% of the United States, are the elected Republican officials who are now scared shitless of that base, or who want to try to harness that power to be these cult-like figures like Trump. That's what they want to do, and that's how they want to use it. So here we have this unity of pro-democracy against the creep of fascism. It couldn't be more binary than what we're seeing right now on display at the Jan 6th. And as we hear about, we heard about the hearing, confidential informants within the Proud Boys said, no, we were going to try to murder Mike Pence. if we had the opportunity. The noose that was out there was to be used against Mike Pence and Nancy Pelosi. And then with the elected Republicans, the Ted Cruzes and the Jim Jordans and the Gates, when they look at that and go, who cares? Not big news, boring, just shows you how far this current Republican Party has fallen from what the great values, what the great ideals are, and what this country stands for. We had a lot of news to unpack on this episode of LegalAF. Thanks for sticking with us as we went through all of those issues. And I know I teased Ginny Thomas. I'll just tell you what the Ginny Thomas thing was just super quickly. There's more emails and messages from Ginny Thomas to John Eastman. We already know that she's been reaching out to the legislatures like in Arizona. We know that she was involved in putting together these fake electoral slates. And finally, the January 6th committee has sent a letter to her saying, we want to have a conversation with you. And so we'll keep you updated on all the Ginny Thomas. It's just so absurd that you have a Supreme Court justice's wife who was integrally involved with that Supreme Court justice, we know, as part of their political leanings and their involvement. It wasn't just like,
well, we're going to follow, not today, but we're going to follow Eastman, Thomas, and her husband. And on that last note you just said, she went on some right-wing news organization on one of the days of the hearing and said she'd be happy to come before the Jan 6 committee. Let's see.
Welcome to the Jan 6 committee, Ginny Thomas. I don't think that you will be true to your word. Everybody, thank you for watching this and listening to this edition of LegalAF. I'm Ben Meiselas. That's Michael Popok. Check out Meidas merch at store.MeidasTouch.com, store.MeidasTouch.com. Special thanks to our sponsor, Athletic Greens. We'll see you next time on LegalAF, delivering the most consequential news to you each and every week. Ben Meiselas and Michael Popok signing off. Special shout out to the Meidas Mighty.